but we do have a few bad apples.
Officials use the phrase
to weed out the bad apples
after some accusations of misconduct or excessive force.
There are some bad apples in there.
But protections built into union contracts can make it difficult for some departments to get rid of those bad apples and for citizens to often determine if a bad apple even exists.
We've erected a system of extraordinary protections that protect these bad apples.
Early 20s, he went to a donut shop in Palo Alto, California in July of 2019.
Video shows Julio Arevalo being stopped by police outside that California donut shop.
Why am I being detained for? You're on probation. Let go of me.
According to a lawsuit,
Hey! Hey! Ah!
officers knocked him unconscious, shattered his eye socket, and gave him a concussion.
You okay?
This officer, without any sort of legal justification or without any sort of aggravation or escalation on the part of Julio Arevalo, this officer proceeded to attack Julio, physically assault him, and very seriously injure him.
Some officers on the scene seem to care little about his condition.
You guys okay?
Yeah. Cool, thanks. How's it
I
going?
don't care about that.
Thanks for coming.
Yeah, thank you. Appreciate
Lovely citizen.
it. I know, right?
That lawsuit alleges excessive force, which Arevalo's attorney says is a pattern in the department.
Come on out! Come on! Come on!
In fact, last year he filed a lawsuit against one of the same officers who was also involved in this incident, a lawsuit the department settled for more than $500,000. But he says this is a pattern that's been difficult to prove in both cases because he hasn't been able to get much in terms of records of past misconduct complaints or investigations of the officers involved in the case. Language in the Palo Alto Police Union contract protects officers with misconduct history. The contract allows officers to request reprimands, probations, and suspensions to be sealed within as little as a year. But through news reports and previous court cases, Arevalo's attorney has pieced together the officer involved has multiple accusations of excessive use of force. Should an officer like that be allowed to have past discipline essentially erased?
Well, absolutely not. I mean, the problem is that the agency has enabled him and they've empowered him because instead of terminating him, they promoted him.
We requested the disciplinary records of the main officer involved. We received the internal investigation files related to Arevalo's case. In those, a lieutenant found the use of force to be reasonable. But in the lawsuit, Arevalo's attorney says there's a conflicted system of investigating misconduct allegations there because he says the lieutenant and the officer involved are good friends, the investigator serving as a groomsman in the officer's wedding. It said it had other documents but didn't send them, saying they are protected under California law.
The system is set up to protect officers when they do wrong.
We analyzed more than 100 police union contracts, policy manuals, and officers' Bill of Rights. What we found, provisions that allow officers with misconduct to hide behind these shields of protection, limiting transparency. 40% of the contracts allow officers' past misconduct records to be erased or sealed. 80% contain protections that limit discipline and disciplinary oversight, like disqualifying officers' first offenses. And nearly half set time limits on internal grievances or citizen complaints. And more than 2/3 restrict or delay the interrogation process of officers accused of wrongdoing.
I think it's not only an unfair advantage, it treats police officers as an exalted class. It treats police officers with special enhanced rights that an individual citizen doesn't enjoy, a firefighter doesn't enjoy, the building permit inspector doesn't enjoy, elected officials don't enjoy, doctors don't enjoy.
Gary Lippman has negotiated around 100 union contracts.
So in many of these jurisdictions, I'm sure the employer gets the last word as to whether the agreement is going to be sealed. whether those terms are going to be acceptable.
Lippman says police are fired all the time, but when officers go before arbitrators, they're at a disadvantage.
We begin at a huge deficit. The employer controls the records.
Lippman says contracts provide necessary protections in a profession he calls the most micromanaged.
I can say that taking away collective bargaining rights from law enforcement officers or stripping out qualified immunity, to me, it's akin to if you got a prosecutor who keeps going to trial and keeps losing, is the problem with our jury system, or is the problem that maybe the prosecutor is not selecting or advancing their cases in a way that's as effective as it should be?
These protections came into play with the shooting of an unarmed man in Bakersfield, California.
James had no criminal history.
Officers killed James De La Rosa after pulling him over.
They shot a total of 9 rounds at him.
According to various news reports, 2 of the 4 officers involved in De La Rosa's death had previous criminal allegations or were involved in other shootings. After De La Rosa's death, the family searched for answers and records.
Yeah, everything was hush-hush. You could not get nothing.
Family members allege the department didn't respond when they asked for witness videos.
We've heard there was a recording, but we've never seen it.
The family wants transparency.
Officers should be held at the same accountability as a professional citizen.
Transparency, they believe, might help unmask what some police departments have labeled bad apples.
Yes, we have bad apples in the police department. We have bad apples everywhere.
That give other officers a bad name.
Police officers are very nice and friendly, but there are some bad apples in every batch. Please believe it.